separate instruction, don't concern yourself with the subject of penalty or punishment in the guilt phase. I've combined those two things together, so take a look at that. I think it reads better than trying to do two separate, potentially contradictory instructions. I think it does it in a way that makes it more understandable. Other than that, they're very, very stock instructions. If there are other instructions that the parties want to be included in the pre-approval, for example, any stipulations that they want me to advise the jury of, let me know by submitting a request and copying my law clerk on that as well. I think you'll probably get before too long a set of post-proof instructions that are very loose in the sense that obviously I can't anticipate everything. It is based on what I sort of understand now. But it's helpful to have a discussion about that as early as possible so that we're all singing from the same hymnal in terms of what the likely instructions are going to be. And for better or worse, as you know, the Supreme Court in last year, 2024, revised all their capital instructions. And so in light of that, I will be as much as possible sticking with what they have provided, given that it's clear they've obviously given it recent thought. And so I think that best insulates the case from perceived error by the court is by using instructions they've recently given us. My plan would be, if there is a guilty verdict on the any of the counts of murder, would begin the penalty phase as soon thereafter as we can. Certainly, probably the next day, unless it's Friday morning when we get that, then we may not start till Monday or something. But given that the jury will certainly be sequestered during that process, the plan would be to go forward. I also will use as much time as I told you throughout the day to get that accomplished as we can. If that happens and we are in a penalty phase and there is a finding of aggravating circumstances, or then the court's discretion about which penalty to impose is pretty limited in terms of my discretion. In fact, i.e. none. It's either life without parole or death, right? In that case, I just want to get, before we get to that, defense's position on sentencing for the burglary charge, if they have concerns about sentencing at that time as well, given that it's probably not even a tail wag on the dog, let alone wagging the dog. So, but I'm not going to make you tell me that now, but I will ask you before the jury goes out what you want to do. I'm going to hand you another piece of paper that I would like to get back from the defense sometime in late June or early July, which is a declaration of last best offer. In other words, identifying whether the defendant received an offer and whether he has accepted, rejected, et cetera, just so that for purposes of post-conviction, we documented that. Okay.